So in the Pretorius case, Pretorius, the applicant, applied for an interdict to restrain Glas, the respondent, its fellow co-owners' use of the road on the co-owned property, and to stop or prohibit Nefdt, the other respondent, the first respondent, from using the road at all. Now, please note that Nefdt was not a co-owner of the farm. So the facts can be described as follows. The applicant and respondents were co-owners of a 1/2 share in the farm each. Glas transported lime from the farm of the first respondent to the marketplace, while the road was constructed by the applicant and the second respondent to transport limes from a quarry on the farm itself. So that was the purpose for which the road was constructed by the two co-owners, Pretorius and Glas. Moreover, the second respondent, Glas, also gave the first respondent, Nefdt, who wasn't a co-owner, permission to use the road across the farm without obtaining consent from the other co-owner first, namely Pretorius. These events gave rise to the application for an interdict. Now, the applicant argued that the use of the road by the first respondent, so not the co-owner, Nefdt, constituted an infringement of the applicant's rights since the second respondent, the co-owner of the road, did not obtain the consent of the applicant as the other co-owner to allow a third party to use the road. Also, the applicant argued that the second respondent, in other words, his co-owner, can be debarred from using the road if the road is not used for the agreed upon purposes. Since the second respondent did not use the road for the agreed upon purposes, which is to transport limes from a quarry on the farm, the second respondent rather used the road to transport lime from the farm of the first respondent to the market. So the applicant argued that the use that the co-owner was putting the road to was not was contrary to the agreed upon use. Now, since the second respondent did not use the road for the agreed upon purposes and changed the use thereof, the applicant could veto the change in use that the second respondent made, and that the applicant does not agree with it. Okay, so basically then what the applicant was arguing was that because the co-owner wasn't using it according to the agreed upon use, he, as the other co-owner, the minority co-owner, can veto this use right and say that it's an unreasonable use, and therefore he can veto it. Okay, so we'll have a look at what this right to veto looks like and what it means later on in our slides. But for now, let's just focus on this case in front of us. So the respondents argued in response to this, or these two claims and arguments, that for an interdict to succeed, there must be proof of irreparable harm, and the applicant does not set out to prove this, therefore the interdict cannot be granted. Also, the respondent, as co-owner, used the road in a reasonable manner since its use was not to the exclusion of other co-owners. The argument was also that the rights given to Nefdt was an alienation of a part of the second respondent's undivided share in the ownership of the property. This is allowed since a co-owner is allowed to lease its undivided rights or undivided shares in the property. And we'll have a look at what can be done with this undivided co-ownership share in more detail when we get to the rights and obligations with regard to specifically the undivided co-ownership share in the next narration. So what did the court say about these arguments made by the applicant, and then the counter-arguments or replies that was given by the respondents? So the court held that the applicant must show requirements for an interdict, namely that a right of hers was being infringed, and that she was entitled to enforce by way of an interdict. Since she had 1/2 of the co-ownership share over the farm, the court held that this requirement was met. She could show a clear right because co-ownership is a real right. The question that remained was whether her co-ownership share was infringed. First of all, by the way in which the second respondent, Glas, was using the property, and second of all, the fact that the first respondent, as the co-owner, um, as a third party, so not a co-owner, was using the property without his consent. There would be an infringement if the law did not permit the second respondent to use the property in the way he was using the property, and if the law also did not allow the first respondent's use of the road without the consent of the other owners. So if the law did not permit these uses, they would amount to unreasonable use. In terms of the first ground raised by the applicant, the court held that the second respondent used the property for purposes of transporting lime and was entitled to do so. This right to transport the lime on joint co-owned property cannot be limited to only transporting the lime on the farm itself to the extent that it then excludes transporting limes to other farms. The court therefore held that Glas's use was in terms of the co-ownership share or his co-ownership share. Thus, the applicant's share was not prejudiced by the second respondent's use of the road. So the other co-owner's use of the road. So the other co-owner's use was held to not be unreasonable use. In terms of the second ground for the granting of an interdict, that pertains to the third party that was allocated use rights without consent of all the co-owners. The court said that the central issue is whether the second respondent alienated only a portion of his rights, which he is entitled to, or whether he has substantially, so far as his right of passage is concerned, with reference to the road in question, imposed another co-owner on the other joint owners by granting the first respondent a right to use the road without their consent. The court held that by allowing the first respondent to use the property or road without the consent of the other co-owner, this did amount to the second respondent imposing an additional co-owner into the co-ownership relationship. This, together with the fact that the second respondent continued to also use the road, constitutes disproportionate use on the side of the second respondent, and therefore constitutes unreasonable use. Unreasonable use then can satisfy the second requirement for the interdict, that there is irreparable harm or imminent harm, if the interdict is not granted. So the interdict was granted in favor of the applicant, specifically to stop the first respondent from using the road. In other words, unilaterally granting use rights to third parties, which then, while also the co-owner is using the property, him or herself, inevitably leads to unreasonable use because it's an imposition of an additional co-owner in the co-ownership relationship, together with disproportionate use. So that would constitute unreasonable use that would meet the second requirement of an interdict.